like to welcome all of you, whether you are in Whitehorse, across the Yukon, across Canada, or maybe somewhere else on the globe. My name is Tom Elliott, and I am your moderator today. I'd like to begin by acknowledging that this broadcast is taking place in the traditional territory of the Kwamna First Nation and the Tonquachin Council, people who have lived here for thousands, if not tens of thousands of years. We have today for you 3 speakers, each with a little different perspective. I will introduce them momentarily. They will take questions from you both during the course of their presentation, certainly at the end, and there'll also be a bit of time. We've built into the schedule a bit of time for questions near at the very end. We are set to go to 1:30 p.m. Yukon time, and I will make sure as the moderator and referee, if you will, make sure that we observe that time. So let me first just give you a brief overview of our 3 speakers today. All of you would have received from the Law Society of Yukon a summary of each of the CVs of our speakers, but let me just speak to it. And bear with me, I'm going to adjust my camera. We've switched computers and offices and a number of movements this morning, trying to get the technology working for us. So if you see me looking like I'm about to jump out the window, I'm not. I'm simply moving the camera. But let me first go to Dr. Reagan Gale. She's joining us today from Kingston, Ontario, that lovely city on Lake Ontario. She has a geographically interesting resume, amongst other things. She's been a clinical neuropsychologist since 2012, and she is currently the president-elect of the College of Alberta Psychologists. So here we are in Alberta all of a sudden, but she has also been a past member of Yukon's Capability and Consent Board, certainly a very active and challenging board to sit on. She's also been appointed as the PGT for Yukon, and by that I mean the public guardian and trustee. And the rest of her resume you will have, or summary of her resume you will have in front of you. And our next speaker, and I'm introducing the order they're going to speak. Secondly is Michelle Rabeau, and she is joining us from her office in Whitehorse. Michelle has a master's degree in social work, and she is currently the supervisor of victim services with the Victim Services branch of the Department of Justice, Government of Yukon, and she works directly with victims in the criminal court system. And finally, we'll have Dan Shier speak to us. Dan, a well-known and lawyer here in Whitehorse, has called to the bar of both BC and Yukon way back when in 1988. And he has spent his career mostly in civil litigation and mostly, if not exclusively, acting for plaintiffs. And most of his focus has been people who have been injured as a result of suffering some form of emotional trauma. And there's more information about Dan in the material from the Law Society. So without further ado, let us turn to Dr. Reagan Gale from Kingston.
Thanks, Tom. Hi, everybody. I might be in Kingston today, but my heart sure lives in Yukon. So I'm just going to move on. I'm the first presenter, as Tom said. You will see that my slides are fairly nutrient rich or quite dense. So I have endeavored to include references for most of the material that I'll be summarizing and speaking about today. So please feel free to go back. Many of the resources or the references that I've included in this slide deck are available within the public domain for future reading if you're interested. The other thing I would encourage you to consider as we proceed today, although the focus of our presentation is really around working with victims, for my component of the presentation particularly, I would also encourage you to think about not just the victims that you may have worked with within the justice system, the court process, but perhaps also colleagues, other people who work with you and alongside you within the broader system. Okay, so for my component of this afternoon's presentation, I'm hoping that you will come away from my component the next 25 minutes having an understanding of the difference between stress and trauma. You'll have a basic understanding of how trauma affects our brain, how we behave, and our cognition, and most specifically our memory. I'm hoping that you will come away with a basic understanding of trauma-informed healthcare. And I hope to set the stage for you for Michelle and Dan, who will speak more about trauma-informed practices within the justice system more broadly. So I'm going to first begin by speaking about stress. So we've all experienced stress before. Stress is the way our body reacts to something in our environment, and that can be physiological. We can have our blood pressure increases, our heart rate increases, we breathe faster. We can also experience changes in our thinking, so we can have worries or stressful thoughts and changes in our emotions. What I want to emphasize is that stress is both normal, natural, and adaptive at times. So you'll see in the graph or the image on the right-hand bottom of the screen what we call the Yerkes-Dodson bell curve. I don't know why law is in there, not just because we're presenting to the Law Society today, but you'll see this curve reflects a psychological theory relatively well validated, that there is in fact an optimal level of stress, where if we have no stress or very little stress, our performance isn't quite as good. And if we have too much stress, or the stress becomes overwhelming, our performance also declines. But there's this optimal level of stress that appears to help us respond most adaptively. So how is stress then different from trauma? Now, if you do a Google definition search or pull out any one of your dictionaries, you're probably going to see many different definitions for trauma. So here are some ones that I was able to find, just as an example of what you'll find and how trauma is defined and conceptualized. So CAMH, the Center for Addiction and Mental Health, defines it as a lasting emotional response that often results from living through a distressful event. The American Substance Use and Mental Health Services Administration published this definition of trauma, which is fairly well accepted. Individual trauma results from an event or a series of events or a set of circumstances that is experienced by an individual as physically or emotionally harmful. Anyway, you don't need me to read the definition. You can see it up there on the slide. And then another bullet at the end, another potential definition of trauma: a situation or event that a person simply can't cope with, leaving them in a state of extreme fear, afraid of death, destruction, or harm. So from my perspective and my practice as a psychologist who often assessing within a medical legal framework, this is how I think about trauma. Something bad happens. So something aversive happens to the individual or someone close to them. And the individual experiences that event as overwhelming or beyond their current capacity to cope, which amplifies that experience of fear, sense of danger. In response to those feelings of being overwhelmed and unable to cope, there are often also feelings of powerlessness that compound and deepen and magnify that sense of threat and risk. And in response to those previous steps, often which are happening faster than I could certainly describe them, the individual experiences fear, anger, and sadness, which last not just in the moment, but can last across time. So while the diagnostic approach that most often used in North America, the DSM, focuses on a certain type of trauma. You'll see here, I've called them big T types of trauma. There's also increasing awareness in the mental health literature that there are other types of experiences that can also be experienced as traumatic. So the big T types of trauma would be things like surviving a war, surviving a natural disaster, experiencing some kind of abuse or assault, being in an MVC, or witnessing somebody else get hurt, for example. But little T traumas would be things like a really profound failure experience, or a significant interpersonal loss, or even bullying, chronic interpersonal changes and conflict. Some people, there are some theorists and psychologists who write that racism and eco-violence are themselves causes of significant trauma. These little T traumas that you'll see on the right side of the slide are often a series of repeated or chronic or ongoing events rather than a single large index event, such as you might see as a big T type of trauma. And so most of us are probably familiar with at least the diagnostic label of PTSD. And Dan very kindly commented as we were preparing for today's slide that there is a typo in the bottom of this infographic. So this should say substance use at the bottom, but so in PTSD, a post-traumatic syndrome that we have a diagnostic profile for within the DSM. You can think about PTSD as representing a series of symptom buckets. One of the buckets is an avoidance of things, events, reminders that create in the individual memories of the traumatic experience. So avoidance behaviors. We also see changes in negative thinking or negative affect. So people tend to start to believe bad things. The world is an unsafe place. People are unsafe. So changes in negative understanding of the world. And then we also see intrusive re-experiencing. So flashbacks, nightmares, things like that. So those are the main buckets of symptoms that you would expect to see in a post-traumatic stress disorder. But PTSD is not the only type of post-traumatic syndrome that exists. And so for this next slide, I'm not going to spend a great deal of time on it, but maybe when you get the handouts, we will be circulating the handouts through the Law Society after today's presentation. Pull up this slide and do this checklist for yourself if you're interested. This is a checklist for adults of adverse childhood experiences. And the literature would suggest that the more of these experiences you have, the more likely you are to have negative health outcomes as an adult. So maybe come back and do this later if you're interested in that. There is a phenomenon that we are increasingly recognizing as developmental trauma. This term was introduced to describe the impact of multiple childhood traumatic experiences and is different from PTSD in one important way, at least, that developmental trauma is not a diagnosis that is available to me within the DSM framework for diagnoses. So developmental trauma describes the impact of early and repeated trauma and loss, often in the context of those significant relationships, because in childhood, of course, we're much more dependent on those trusted adults to provide our safety. Going back to those adverse childhood experiences, you'll see that many of them relate back to those major relationships we have as children, but I'll stop skipping around. So there is a strong association between exposure to trauma in childhood and, as I said, just about every negative health outcome one can experience as an adult, including mental health challenges, but also domestic violence, also obesity, physical inactivity, or morbidity, mortality rates are higher. Developmental trauma is also variably referred to as complex PTSD or CPTSD, which can be thought of as the experience of multiple traumatic experiences, often beginning in childhood. And by the time people reach adulthood, there's often kind of a weave together of both those big T and the little t types of trauma. So here's another infographic that really you could come back to later that shows how the major symptom buckets, if you were, of PTSD on the left side of this infographic are kind of expanded upon when we see or we're working with individuals who have that early exposure to complex trauma. So we go beyond things like avoidance and re-experiencing to things like chronic difficulties with emotional regulation, disrupted relationships, impairment in relationships, as well as those core buckets that we might see in PTSD. So how does this all work then? How does it work, right? What is the neurobiology of trauma? And heaven knows, Tom, you better keep your eye on the clock because we could spend the whole afternoon talking about this and not cover everything that the literature has to say. So this is really, really brief. And if you are interested in traumatology and know this research well, forgive me for how much I will condense it. But essentially, this is what we think the mechanism, how trauma affects the brain. There is that one aversive event, if you recall that the individual experience is as overwhelming. They have that deep sense of fear and powerlessness, which compounds their sense of threat. In response to that, a series of stress hormones get produced by the brain. Adrenaline, epinephrine, noradrenaline, norepinephrine get produced. And that in turn produces a cascade of changes in both the structure and the function of how the brain works. So what we see across time, and these are some of the behaviors or the cognitive changes that we see subsequent to that, perhaps that overexposure to these stress neurochemicals. We see a greater pairing of of the traumatic memories and the emotions, those negative emotions that often go with the experience. We see that distress then being generalized maybe to more non-specific or stimuli. You can come back to this slide later. I'm going to go on to my next infographic, which is, for a brain geek, even richer. So here is a nice cross-section drawing of the brain, and here are some of the regions that we think are specifically affected by that overproduction or the response, the neurochemicals that our brain produces, those stress hormones, in response to that index trauma that we experience as overwhelming. So you'll see there are lots of different parts. Again, we're talking about the structure of the brain. There are many different structures that we think are affected by the experience of trauma. I would draw your attention for this presentation specifically to the red and the blue bits at the bottom. So this red bit is the amygdala, which is often thought of as the part of our brain that is responsible for emotions. And so with an overactivation of the amygdala, which is sometimes what we see as a result of this stress response, people develop conditioned fear or increase responsiveness to that traumatic stimuli. If you recall on the previous slide, one of the hypotheses of how trauma kind of perpetuates itself across time is that people become increasingly reactive and sensitive to stimuli that might not have been traumatic initially, but there's an increased sensitization. The other part of the brain I'd like you to note here is the blue bitty down to the bottom here, the hippocampus. The hippocampus is the part of your brain that is most involved with encoding or making new memories. So this is where your memories are consolidated before, in the long term, they become long-term memories and they're kind of distributed across your gray matter. So in a post-traumatic syndrome, we see things like that we see the priming of those memories. So if you recall the re-experiencing of traumatic events, those memories, those intrusive memories becoming more prominent, the hippocampus is implicated in those. Okay. All that, and we know that 3 people can experience the same index trauma event and have very different reactions. So why is that? When we have a fairly decent understanding of the neurobiology of trauma, why is it that we see this heterogeneity in response and these multiple trajectories? And I found this article as a this is like an article title that makes psychologists laugh. 600,000 ways to have PTSD. This is really an article critiquing the nosology of how we diagnose. Again, don't get me on that tangent. But there are certainly many different ways trauma presents. And we really think this relates to risk and resilience. And you could perhaps think about this in the context of maybe thin or crumbling skull. Maybe that's language that you're familiar with. So what might create a thin or a crumbling skull for somebody to experience a post-traumatic symptomatology are things like previous trauma, like a developmental experience of trauma, as we discussed, a lack of social support. There is a role for heredity as well and genetics in terms of how our brains respond to stress, but also the social determinants of health. Kind of what other stressors do you have happening, and what perhaps other comorbid health conditions do you have? Those are all risk factors that increase the risk of a significant post-traumatic response. And in fact, when we look at PTSD, recovery from PTSD across time, we do see that heterogeneity. So we see that in many people, some people recover, right? We see this recovery group. On the x-axis here, we have disruptions in functioning, where the higher the line is, the more impaired the individual's functioning is. And we can see that we can often break people into 4 different groups, really, where some people experience trauma and they appear to maintain that they maintain that chronically elevated level of trauma response without recovery or resolution, which would be this group down here. Interestingly, we also see this group where they experience the index trauma, they appear to get better for a while, and then they get worse again. So the other thing to highlight, I wanted to highlight for you, is that the response to trauma is also not linear. You can have a trauma experience and keep it all together until something else happens, and then you deteriorate. So the literature is clear that that's not uncommon at all. So I'd say about 50.
If I can interrupt, sorry to interrupt.
Please.
This is your 5-minute warning.
I'll try not to speak even faster, but thank you, Tom, keeping me honest. I will let you review the content of this slide later, but suffice it to say, about, I'd say, 15, 20 years ago, there was an increasing recognition that receiving healthcare could be traumatic for patients. For example, when an individual feels unsafe when they have to, with the provider they're with. And in response to that was the evolution of trauma-informed approaches to healthcare. While you will find different definitions of what trauma-informed care looks like, most of them share these 5 foundations. Things like ensuring that the patient determines that the patient is safe, that the patient has choice. So the choice of treatment, for example, gets transferred to the patient. Decisions are shared with the patient. There is consistency and task clarity, and that the patient is empowered through the care provision process. And in many ways, trauma-informed care maps quite closely to definitions of cultural safety. If you've been following the literature on culturally safe healthcare practice, there are many similarities there. This is a fabulous definition, great infographic. I would strongly encourage you to review the reference that I cite there if you're interested in learning more. When it comes down to it, though, trauma-informed approaches to care really emphasize the sharing of power with the patient. So that in the traditional approach was that as the clinician, I'm the expert, right? I hold the information. I know what's best for you. Trauma-informed approaches transfer that dynamic, sharing the power with the patient. So my questions for you on the call today working within the court system, as I assume many of you do, I wanted to ask, what are the things that you can control within your practice working within the court system? And here were some of the things that I thought about. You know, you can maybe control some of the hours you work. You can pick your litigation strategy. Maybe you can control how you negotiate your work-life balance, remembering that even if it's difficult, your work doesn't have to be your life. But there are, it seems to me, diminishing levels of control and power. For example, the defendant appeared to me to perhaps have relatively greater levels of power and control for choice than the victim might. And so what does this mean for you as counsel? What we know from the Shier report is that the biggest risk factor for practicing lawyers for burnout is dealing with the emotional demands of clients. And so what I would suggest is that finding different ways to work with clients who have experienced trauma might also be protective for you as counsel. Because how does trauma show up? It's going to show up in your office. It's going to show up in court. And maybe this sounds familiar. And again, this is maybe don't just think about clients, maybe also think about colleagues in the system. Trauma shows up with significant anger and irritability, mistrust, criticism of authority, potentially higher risk behaviors, impulsive behaviors, reduced inhibition, emotional lability, tendencies to become quite tearful or quite angry at the drop of a hat, but also things like what appears to be increased distractibility or inattention, maybe delayed reporting or minimizing the trauma experience, avoiding activities, becoming isolated, maybe not responding to your calls or just kind of appearing to be checked out. So that sense of detachment from even themselves, but also what's happening in their environment. I think I'll stop here, Tom, before I take questions, but I did want to end here. We know quite clearly that the experience of having a trauma experience affects how memories are encoded. If you recall, I drew your attention to that, the red bit and the blue bit. And the blue bit on that side, in particular, the hippocampus, is involved with how we lay down memories in our brain. So with extreme stress and the production of those, the stress hormones in our brain, the normal activity of the hippocampus is disrupted, which means that when it comes time for us to retrieve memories, that this memory retrieval, the things that we do recall might not be in a chronological order. They may not be linear. They may not even appear cohesive. In fact, this is a quotation from Justice, that memories of traumatic experiences tend to be fragmented, associated with intense arousal, readily primed and triggered, and poorly contextualized. And so what that means for you and for this talk specifically is that witnesses who have experienced trauma may not be able to describe their experience to you in a linear or chronological fashion. They may respond inconsistently across interviews. And that's not because of feigning or confabulation. It's because of the way, it's because of the neurobiology of trauma. And the literature is also clear that how we speak with witnesses who have experienced trauma how we speak can affect how they respond to us. So if the way we deal with witnesses triggers their feelings of being threatened, then they are likely to be perhaps even poorer historians to our subjective appraisal. It might make it more difficult for them to respond consistently. So I have some terms here to know and some references, including a podcast from the CBA, looked pretty good, and a trauma-informed legal practice toolkit. I think Dan will be taking us back to that before we wrap up today. Questions. And I don't know, Tom, how that works. Do you just manage the chat, or are people able to unmute themselves?
Dr. Gale and everybody who's listening, I don't seem to have the ability in my current screen to manage the chat. So what I would ask is that if any of
We have a, yes, we have a chat. We just had a question in the chat. Can we have the slides? Absolutely. You will all be getting the slides by PDF after our presentation today. Great question.
Okay.
Other questions?
And if you have a question, please identify yourself and where you are situated. Well, hearing no more questions, I've now found the chat room. I see no further questions in the chat room, nor do I hear any. So, Dr. Gale, thank you. And folks, bear in mind that at the end, the way we plan this session is there will be an opportunity for further questions if something occurs to you over the next little while. So, okay, now we're going to turn to Michelle Rabeau, and Michelle, I'd ask you to please take it away.
You're muted, Michelle.
Thank you, Tom. Reagan, I'll just say slide for when I want it moved. Okay. So the reason that this presentation came up, I think, started, well, I'm not sure of all the background, but I know that Leo Lane had listened to a podcast on the Osgood podcast site, and it was by a civil lawyer named Jillian Hanachu. I hope I'm pronouncing that right. And she specializes in responding to victims of sexualized violence. And her podcast was about basically the differences between civil processes and criminal processes and the outcomes for victims in both. And not unsurprisingly, the outcome for victims in criminal processes was worse. So Dan, after this, will talk about the civil process. I won't talk about that at all. I'm going to talk about the criminal process. And as mentioned before, I'm not a lawyer. I am a social worker. So I work daily with victims, and I'm not an expert on law-based research or case law. And I was panicked that maybe I had to learn it all before this presentation, but I thought it was more important that I focus on what I know, and mainly because I'll do better, but also because I think it's important to expand our philosophies on how to respond to victims outside of what is just said in the law, and try to think strategic or creatively outside of the parameters of the law, because I think it's easy in the criminal system to kind of get stuck there. And I also am coming here with hope and from a place of hope. And I do, there's lots of flaws in the criminal process, but I do think working together that some of those can be addressed, and victims can have better outcomes. Slide. So Reagan made me do learning objectives because she was prepared, and I think it's a good idea. So I said, yes, I will do that. So what I'm going to talk about today, I'll talk a little bit about victim services, just in case people don't know what I do. I'll talk a bit about some legislation that references and speaks to victims. And then I'm going to talk about strategies for increasing victim satisfaction in the criminal process. So victim services works with victims of all crime, no matter when it happened or whether or not it was reported to the police. And it's a government organization, a government unit. Victim services is voluntary, so people have to agree to come. We don't proactively seek people. They are referred to us or they seek us out on their own. So that's consent-based, and it's victim-led. And victim-led is pretty important to what we do, and that means we are following the lead of victims and helping them in what they are identifying as what is most important to them. So some people want to be in the process, some people don't, some want their conditions. They want no contacts with the person who's harmed them. Some people, probably half of the intimate partner violence files that we have are people coming to us and saying, this guy's on no contact with me and I would like those contact conditions lifted. I want to be together with them. And we work collaboratively with lots of partners in justice. We work collaboratively with Crown, with police, with probation, with family and children's services. But sometimes we're not working collaboratively because that's not what the victim wants. So sometimes it feels like we're working in opposition, and maybe we even are working in opposition, but we're supporting what victims want out of the process and trying to give them the information that they need to make informed choices about that. Slide. So just briefly, the services we provide are crisis support and counseling. We do court updates. We're at every single docket court in the Yukon and every community, and we go to trials and sentencing if we have a victim that we're connected with. We give information, navigation, we explore options, we go places with people. So we're often in Crown appointments, we go to the hospital, we go to the police. We help people get protective orders. So emergency intervention orders were designates under the Family Violence Prevention Act. And we help people with peace bonds. So we don't run hearings, but we get people to talk to the JP and get hearings set, and we'll go with them to those hearings. We have an emergency fund, we give out cell phones, and we do a lot of case coordination with different organizations. Slide. We also have some programs besides just the frontline program that I'm mostly talking about, but we have a program responding to child and youth victims and witnesses. We coordinate and respond in the sexual assault response team. We have an independent legal advice project, which is 4 hours of free legal advice to victims of intimate partner and intimate partner violence and sexualized violence. And that's a variety of different kind of law: criminal, family, immigration, civil, housing, I think are the most ones that we use. We have a family information liaison unit responding to families of murdered and missing Indigenous women and girls, and we respond to critical incidents. So for instance, the homicide that happened in Faro a couple of years ago, we, with mental health, organized a response of people, had a calendar of people going out, and I sent some of my workers out there as well, who were there for a couple of weeks. Slide. So mostly I want to talk about how we're going to consider victims in the criminal system. So I just begin this by stressing, I know I'm a victims advocate. I know I'm not a lawyer, but I do understand the fundamentals of innocent until proven guilty and how our criminal system works. And I do note that when I work with victims and they're really frustrated and mad about the system, I do talk about those rights. And if you were wrongly accused, you would want to have those rights as well. So I do stress that I understand that, and my staff understand that. But saying that, I want everybody here listening, and I'm not sure how many are here, but consider for a moment, you know court, you know law. If you were sexually assaulted by someone that you know, so say it was someone you went on a date with, a family member, a coworker you shared a cab with, if you were sexually assaulted by that person, would you go to the police? So I can tell you that I sit on a lot of different tables: the sexual assault response committee, the sexual assault response team, different interagency groups. And when we ask this question of ourselves, the answer is almost always no. And I hear this in my job all the time. I hear people coming to me with options and saying, I don't want to go through with this. I don't want to be part of this system. I talk to victims that have gone through criminal court and say to me after, had I known what that was like, I wouldn't have done that. And I've heard from lots of people that often, not always, but often, or sometimes, the trauma of the court process is worse than the actual incident that caused them harm, that got them involved in the court process. So slide. So I'll just talk a bit about what I hear from victims when they come to see us. And I'm gonna be referencing one specific victim who, when I told her I was doing this, sent me a text that was this long and said, share all of these things. So I'm going to reference her. I think Dan might as well. And she gave us both permission. And it's interesting because she went through the criminal and the civil process. So it's a good comparison. But people tell us they don't want to participate. And that often happens in intimate partner violence when somebody calls the police just to have safety in that moment. The police come, the perpetrator is arrested, and then they're on no contacts. And they come to us and they say, I don't want to go to court. I just wanted them out of the house that night. People talk about court taking over a huge part of their life, and we know that it goes on forever. I looked at the dockets today, for instance, and there's one sentencing today that's been in the system for 923 days. On Supreme Court fixed date, there's something that's been an assault for 400 days. There's a sexual assault for 211 days. So it takes a long time to work through the court process, and people feel their lives are on hold. They ask me, can I go on holiday? They have to get out of school. I'm calling them with updates, and they're constantly like reminded of what happened. People don't understand the rules and the processes of court, and we know that it's a language. And I know it took me just going to court a long time to understand it. And anybody that's worked with me knows I don't even understand it that well. Like there's so much I don't get, and I'm in court all the time. So I'm just going to share a quote from this person who sent me the text. And she said, in reference to the rules, and this was in reference to a victim impact statement. And then they took all my healing words just to let me know how little they care about victims. Removed the words I needed to say to heal. The system is not for us. The publication ban. No one explains that the court will take away your story to protect the pedophile. You can never publicly speak of what happened to you unless the court lifts this ban. I thought my life experiences were my own. This is another violation, and not one person explained anything of this to silence survivors. So we know there's rules around victim impact statements. I understand, and we know why publication bans happen. And I think the intent is to protect victims, but people don't understand all the nuance of all the rules within the process. Decisions are made without consultation or input. And I think decisions are made quickly, and court is slow, slow, slow until it has to move quickly, and things happen. And often victims aren't consulted on that. Victims feel like they're on trial. And I think that question I asked earlier about imagining if you were sexually assaulted, would you go to the police? For me, the answer would be, in a lot of cases, no, because of this feeling like you're on trial and feeling like you're questioned, your integrity is questioned, your reliability is questioned, yourself as a person, it feels like you're being questioned, and you're being questioned on your memory in a way that memory doesn't even work. I don't remember things in a linear fashion. I don't. And I remember being in a traffic accident a couple of years ago. I was hit by somebody. I wrote a statement. I went to the police. I wrote a statement, and I read it after, and it's ridiculous. It's just ridiculous what I wrote because I was traumatized by the accident. And if I was on the stand with that, it would have been really embarrassing and terrible for me. So I can't imagine going to the police with something as intimate as a sexual assault. What she says about that is, so you can go to court and say so you can go to their court and say what they allow you to say. You won't have your own lawyer, even though the rapist is on trial, the victim is on trial, and you won't have a lawyer to help you. People tell me that they feel unsafe, both physically and emotionally. So they feel unsafe in the courtroom. They feel unsafe having to see the accused person. The court is set up in a way that you're interacting with the person that harmed you just going into the courtroom. And this was something that was really important for her. And the reason that I was telling her about this presentation is she talked about, she said, if you want, you can share how he went and sat in the room set aside for victims and say where I would have sat. So he touched things I would have touched. So I felt like I could not sit or touch those things. And there was no smudge in there. And I didn't want anything he touched to touch me or my sister ever again. Also, he and his lawyer stand in front of the washrooms in the victim room, and the whole trial takes safety away. No safety to even use safe spaces. So in that case, we were going to bring her into the witness room, the big witness room in the courthouse, and the accused person was there. And that was a real affront to her. And she didn't feel safe at all in the courtroom. People feel invaded. They have to tell really personal stories. And going back to the example of where you sexually assaulted, imagine telling that story publicly in a way that's not natural to you. People talk about not being physically comfortable. It's not comfortable to sit in that witness box. People talk about not seeing their culture in the process. And people talk about feeling robbed of their dignity. So I'm just noticing the time. I'll go through this quickly. I'm sure everybody knows about the Canadian Victim Bill of Rights, and it awards protection to victims. And I think on a whole, we see these rights being applied in court. So victims have the right to information. They have the right to protection. They have the right to participation, the right to seek restitution, and a right to make a complaint. And I have more details on the slides that'll get sent out, and you can look at the specifics of those rights. However, I would say I think the Victim Bill of Rights is fairly limited, and it gives a bit of rights, but not, I think there was a spirit in creating that bill that isn't necessarily translated to the specific rights that came out of it. So you can just skip a couple there, Reagan. We also have a Yukon Victims of Crime Act, and that was enacted in 2010, I think, 2010. And it's similar to the CVBR, except it's not, it's only a territorial legislation. So not everybody needs to use it or follow it. RCMP and victim services have agreements through this act, and then any kind of government agency, territorial government agency has to follow it, I guess. The reason I like this act is because the preamble talks about victims should be encouraged to participate in the process of justice in ways that preserve their dignity and do not increase their suffering. So I really like that idea, that shift of increasing the dignity of victims in a court process and not making it worse for them coming out. The other thing I'd like people to think about too are the national guidelines for Canadian child advocacy centers and child and youth advocacy centers. So Victim Services has started a child and youth witness program based on the model of a child advocacy center. And ideally, child advocacy centers are one space where a victim can go and access police, specialized Crown, specialized police, specialized counselors, have rooms for forensic interviews, and have training about interviews. So the evidence is sound and it goes to court. They make it better for victims. And I think I know the prosecution outcomes are better in those kind of scenarios. So they have some guidelines. And I think as a court system, thinking about some of those guidelines are helpful for children, but I think they're helpful for all victims. And that's thinking about, well, it says here, child focus setting. And a child focus setting is having a comfortable room for kids with furniture for kids. And I remember a time we supported a 5-year-old to testify, and she testified remotely in the courthouse, but there's only big grown-up chairs there, and she was just down little, she couldn't see. We had to put pillows so she could see, and she wasn't very comfortable. So even like having chairs that kids can fit with cameras that can fit kids. We're hoping to get a dog eventually that we can use with police, and we can use with Crown, and we can use in court, and we can use here, that can also be there to make kids comfortable. But thinking about your space in general for any kind of victim. And having multidisciplinary teams. And I really appreciated the partnerships that we've had with the Crown and we've had with the police. And I think working together and having the different expertise of the different people together has better outcomes for victims. And the sooner victims advocates are included, victims fare better. And diversity and inclusion. And we talked a little bit about cultural competency, but having people that are Indigenous, having judges and lawyers that are Indigenous, having process that is Indigenous led and Indigenous run. And forensic interviews, which isn't necessarily for this audience, but having well-trained RCMP who are doing forensic interviews in ways that are sound for court. So those things inform me when I think about the strategies for victims. And I think about the spirit, and I just want to talk a little bit about some strategies I would suggest. Thinking about the spirit of the Canadian Victim Bill of Rights. So victims have the right to information, protection, and participation. And those are pretty specific and limited, I think, in the Act. But if we could expand that a little bit in our thinking, and if victims had information on when matters are stayed, when there's plea deals, when there's resolutions, when things are brought forward, I think that would help people feel more in control of the system or in control of the process because they know what's going on. I'd also wonder about information about court proceedings in court when there's victims in the court. I've sat through some sentencings where agreed statement of facts are read. And I think even just stopping before that's read to say to the families, I'm about to read these details. There's a lot in here. It might be upsetting to hear. Did people want to take a minute to step out just before I do this? And knowing that people don't understand what's going to happen in court, like what the next step, and kind of and explaining it to victims that are sitting in the courtroom with you, I think would be really helpful to help people in how they're responding to that event. Thinking about protection, I think there's lots of ways we can talk to victims about what they need for protection, and we could talk to them before some of those things happen. So connecting with victims prior to bail, which happens a lot, but talking about the kind of conditions that they want. I do know no contact conditions generally happen and victims generally want them, but sometimes victims don't. And I know in cases where there's an assailant that's unknown to them, they might have witnessed some kind of assault, or they were part of an assault where there's many victims. They feel really vulnerable having their names listed in the no contacts because it's somebody that didn't know them and now knows their name. So having that conversation before those contacts go in, if possible, you know, I know the limits on that, but crafting what would make victims feel safe, I think that we could all do together as a system. And participation, the same. I think victims can have more input into the outcome of what's going to happen. What kind of sentence are you hoping for? What are you looking for? What kind of conditions would be meaningful for you? What do you want me to do next? As much as that can happen, I think that would help people, again, feeling more in control of the outcome. Slide. And I talked a bit about our spaces, I think can help people. We here are building a remote testimony room, and we're building an interview room the police can come to that's going to be technology good. Like we're gonna have the computer set up and the cameras and the microphones, technology good. But as much as we can have those spaces in the courthouse, at our offices, where people feel comfortable and they feel safe, it's culturally safe and they feel welcomed. And places also to practice ceremony as well. That's the other thing. We have the ability here to smudge. We have the ventilation that you need. And I know not every building does. I know that's something we had to add moving into here. But people have come here before court and after court. And if it's possible to smudge at court, I think considering that would be really meaningful to some people. And then the next strategy is training as well. So I am not an expert, but there are some really amazing experts that I think would be great to have come up here or present by Zoom. I've suggested some, and I'm happy to work with the Law Society or anybody in bringing those people up. I do have a training budget and I would love to work with any of these people. So I'm kind of pushing my own agenda here, but Lori Haskell is a psychologist that talks just like Reagan does about the neurobiology of trauma specific to victims and memory. Melanie Randell talks about trauma-informed practices to law, as well as Reagan had sent out a link to about that same topic. Elaine Craig wrote a book called Putting Trials on Trial, which is all about sexual assault laws and rape shield laws and how they are not enacted often in courts and how they could be enacted more. Jillian Hanachu, who I just spoke about, and Dan's going to talk about her more too. She talks about victims in the criminal versus civil process. And then my favorite is Sue Bogle, who's a former Crown here who works with us now. And Sue is an expert on, certainly a Yukon expert, and I think probably becoming a national expert on 276 and 278 applications or third-party record applications, because the law has changed in relation to those. And so I think, I don't know if you've had Sue before, and I don't know what she's thinking right now as I'm saying this, but I think there's some real interesting legal specialization that might speak more to the legal need or the legal, this is why I don't talk about it, legal things you can do to respond to victims in the courtroom. And how we respond matters, and we know that. And we know that people's healing is better when they get a good social response. So being trauma-informed and being response-based, and I didn't get a lot into response-based, but what that means is how you respond matters. The language that you use matters. If you're being victim blaming, victims aren't going to trust you and they're going to have worse outcomes. If you are not using language where you're noting that people resist violence, it can be detrimental. So we know that people will feel better about what's happened to them if we respond to them with compassion and non-judgment and support. And I think Dan's going to talk more about that, and he's going to talk about how he does that in his practice. But I stress that at the very least, if we respond to people well and non-judgmentally, they're going to feel better at the end. And then another strategy is resourcing as well. And I want to note that I know it's exhausting when you're busy. And I just talked to, I got some stats here about how busy everybody is. And I know that last year legal aid opened about 1,200 files. I know that in 2022, courts opened about 1,600 new files. So I don't know how many files Crown have, but if legal aid has 1,200, then Crown's probably going to have that or more. And I know that people are working a lot. I know that based on my conversation quick with Lynn is that lawyers at legal aid have about 100 files each. So I realize that people are busy, and I know it's exhausting when somebody comes and says, do this different, do this different, do this different. But I also don't want that to be a reason victims aren't getting good outcomes out of the court process. And I think the better resource that legal aid is, and the better resource that Crown is, the better outcomes for victims. And I just want to acknowledge, I know people are really busy. But the less court delay and the more time we can have with victims, the better. And I know that everybody in the court process being resourced for that is helpful. Yeah, I just wanted to acknowledge that because I work with people that are working really hard. So I think that's all I have to say. I went pretty quick. I don't know if there's any questions for me.
Well, Michelle, I thank you for that. Thank you for sort of putting the lens of a victim, or allowing us to see the criminal justice system through the lens of a victim. And of course, underlying so much of what you said, that we all remember that less than 10 years ago, 2016, I believe it was, that the impact of victims as witnesses in the criminal justice system really hit the Canadian consciousness with the Jian Ghomeshi trial. And I think many Canadians, it was a aha moment, and probably for some a horrifying to see what happens from time to time in the court system. And that case, which I would consider a bit of a backdrop to your presentation today, allowed everybody to see. So thank you for that. I don't see any questions in the chat room. So I think what I'll do is, in the interest of time, I'm going to turn to Dan, but we'll come back with questions because, Dan, I'll give you a cue at least 5 minutes before 1:30. I guess another way of saying that is 1:25, so that we can go back to our both our presenters and our participants. Dan, you are on mute.
You know, I thought I had it all under control there. Thanks. My talk is about the three elements of the things that I see in my practice when I'm working with people who either tell me that they've gone through a traumatic experience, or I begin to suspect that they would fit the definition of having experienced trauma. And the three elements that come forward the most are these ideas, to me, of power, control, and trust. Power, because trauma often happens in a dynamic of unequal power. Control, because that dynamic leads to a feeling of loss of control by the traumatized person, which carries on through your work with them, because control of the process and control of outcome is very, very much front and center in the work that we're doing. And the legal system, by its very nature, the way that we work in a courtroom on an adversarial basis, is the fact that there is a finder of fact that's going to decide things takes away the control from that traumatized individual. And your client, and certainly mine, I've seen over the years, often feels very uncomfortable with the shifting nature of the case and trying to navigate different levels of control. That causes a heightened level of anxiety for the client who's trying to figure out where do they have control, and often are desperately trying to get that control back. And it often can replicate the trauma of the initial event, as we've seen from previous presentations, that the fact or the process of going through court can be worse in the perception of the individual than the initial event, because it's not the event that's the issue, it's the feelings about that event that are the issue. And those are what carry on in all of our work with our clients. And then that leads to trust. How can a person begin to trust you as their lawyer if their experience has been with people in control and power, having taken advantage of that to the detriment of the traumatized individual? Typically, we start off with no trust and have to work to slowly build trust. And sometimes there's an inappropriate type of trust that we have to navigate. Sometimes there's too much trust expressed. Sometimes that leads to us being put up on a pedestal and easily smacked off when we don't measure up at the particular time that the person is considering how we are acting. So it's a very, very fraught process. Can we look at slide 2? One of my faves, good old Calvin. I thought that this slide and its caption fits both aspects of the dynamic. First of all, the work that we're doing. It seems pretty easy when you get into a case like this, and it can just freeze you trying to figure out, how am I going to navigate this case? But of course, your client is going through that similar process. Paralysis, mental paralysis, even physical paralysis can be a symptom of a person who's experienced trauma. So Calvin said it, and I hope that we can take that to heart. Next slide, please. So yeah, Reagan pushed us for learning objectives. These are the sorts of things I'm going to talk about a trauma-informed legal practice. And I have to warn you, there is no precise definition of that. This is an ongoing process. Another thing that I would hope we can talk about is understanding your client's journey, where they've come from. That can relate to things like the adverse childhood experiences. The third thing is trust. I'll talk a lot about trust today. And number 4, which leads from trust, is how you learn a story and what to expect when you're talking to somebody who's telling you about some very traumatic experiences in their life. Number 5, we rely upon this test of credibility and reliability in court. And I'm going to ask you to think about whether or not it's time to re-examine that test and its applicability in trauma, and in particular, sexual assault trauma. And finally, I'll close with a few cautionary comments about the pitfalls, the things that we can fall into, and the problems we can have, which are going to affect our ability to provide good legal service to our clients. Next slide, please. This is a wonderful resource that Reagan referred to. The Golden Eagle Rising Society has a toolkit, I think it's called. It's difficult to access. You have to go through their website to find it and figure out how to download it. At least it took a while for me. But they do have some really useful pieces of information. It's very informationally dense. There's a lot of stuff. Reagan might have looked at some of the comments by lawyers talking about the neuropathology and thought, wow, what are lawyers talking about that? But it's useful background stuff. And then they get to this idea of what it is to be trauma-informed in your legal process. And that's to understand the impact of trauma on the brain and body. And you actively implement strategies to avoid exacerbating trauma-related problems. I try and stay away from brain and body stuff. I just think about the mind and the person in front of me. Next slide, please. And that one's going to take a while to load. So some fundamental principles. It's all based on RESPECT. You can sing that song when you meet your clients. There's some basic elements to it: providing safety and dignity, respectfully educating your client, because your client may come in having only watched American television about how lawyers solve their case in the space of a 1-hour episode. Doesn't happen that way. It takes years. Most of my cases take years, 4, 5, 6 years to work through, sometimes up to 10 years to work through. Ask them, approach the issue about not that there is something wrong with you. That's how they've been treated all their life. So figure out what is it that they've experienced before putting a label as to what's wrong with them. And recognize that you are going to have, as we all do, clients who act in a way that might not be considered by you in your office as acceptable and maybe difficult, but really is something is going on in the way they're looking at the situation at that time, and it's going to be trauma-based behavior. This is from a really interesting article. I've got the site of a couple of lines down, or a couple slides down, by Mackey and Sheldon on public interest litigation and some strategies for trauma-informed practice. Next slide. How to put it into action. Yes, things do take time. Time is the constant in these cases. You can't expect on a civil side to get through your case very quickly. You've got to allow time for communication and not falling back in the buzzwords that we all use. I mean, language is power, and lawyers, we use terms, ways of speaking, the way we address the court that's completely unfamiliar to our clients. So speak with your client in a way that works for them. Build that relationship, but I will get to a few concerns about how that relationship can unfold in a negative way. Involve trauma experts. We don't know this stuff. I am beginning to think that the courts need an amicus curiae type approach where there is an expert in trauma from a psychological perspective, talking to the judge and helping the judge understand this. So many cases, the judge is called upon to make decisions when they haven't got that training or that ability because they're not a psychologist or a counselor or a social worker to understand fully the impact of trauma on the way that a person has appeared to them and spoken to them in court. And then related to that, consider what you've got in front of you, other lawyers, your client, you, and the judge. Everybody's part of this trauma-informed dynamic to lesser or greater degrees. So be aware of that. Next slide, please. So understand your client's journey. Where have they come from? In this article, which is in the Supreme Court Law Review 2019, there's a comment that almost 2/3 of the general population of the United States has experienced at least one indicia of trauma in the course of childhood. Of course, childhood trauma is not the only type of trauma, but it may inform how a person responds to trauma later on in life. One of the more recent studies has indicated that there is a strong correlation between adverse childhood experiences and traumatic brain injury. It's a correlation. So now the next step is to figure out, does that mean that people who have experienced adverse childhood experiences are more likely to suffer a traumatic brain injury? Or does it mean that they are more likely to have the symptoms that help define the nature of that traumatic brain injury? So we're finding that connection, and it means that you're going to have a lot of people in your office that have come from trauma. It may not be the case that you're working on. You may not be working on a trauma case, but you may have a person who's responding to the things that are going on in that case because they come from trauma. Something you've got to be aware of. Next slide. We can go quickly through this one, but it's very important to be aware of the role of residential school in the lives of many, many of our clients. Next slide. So going back to what Michelle had to say about people talking to the police about their experiences. This is from Vancouver Rape Relief and Women's Shelter. It's a 2018 report based on some older statistics from about 2004 through 2009, I think. But at any rate, when they analyzed the information, 460,000 cases of assault were reported to the interviewers. Of those, less than 10% had been reported to the police. And of those that went to the police, 85% were recorded as a crime, And then of those, only 50% resulted in charges. And of those, only less than 50% went to prosecution. So of that 460,000, 1/4 of the cases that were recorded as crimes went to a conviction. So you've got 1,000 of that 460,000 that actually resulted in a conviction. So the person approaching the criminal justice system is going to be looking at that and saying, what chance do I have of getting a result that adequately reflects the way I'm looking at the world? It's not very encouraging. Next slide. These are some more recent federal government statistics. They're very similar. I just updated the population to about, about 770,000 likely incidents of sexual assault. Very few, again, are reported to the police. The vast majority are not. This report didn't tell us how many went or what percentage went to trial, but the statistics are generally about the same as the previous report. Next slide. So what does this mean for the victim? And this is from this lovely lady who has an unpronounceable last name, Jillian. I'll just call you Jillian if you're listening in. Excellent work, and I'd love to hear you speak again. And this information was kindly provided to me by Michelle. And it's the role of the victim being the person on trial. That's the way it feels to the person who is the complainant. That's the way our cross-examination system works. It's all about poking holes in credibility, poking holes in the story. And as we've learned, people don't remember and articulate their stories and their experiences in a linear, connected way. And they're on trial in the sense that they're in public. They've got to relive that experience. Trauma works that way. When a person is telling their story, they may not have achieved that gulf between the event and their feelings. They may not be at that stage. So when they're telling their story, they're reliving it at that time. They're being re-traumatized. Whether that's the intent of the process or not, that's often what's happening. And as Michelle's pointed out, who do they talk to? The Crown is not their lawyer. There's nobody in the system that is their lawyer, except somebody who, like Sue Bogle, who's providing a limited area of legal advice to them. So they're not the center of the case anymore, but they're the one who came forward in the first place. And we tend to look at these cases in the criminal sphere as being crimes against society. They're not. They're crimes against an individual. And I think we need to consider reevaluating our focus in these cases. Next slide.
Dan, sorry to tell you this, but this is your 3-minute warning.
My 3-minute warning, I'm going to have to go fast. Okay, trust. It's all about trust, 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 trust. Keep that in mind. Next slide. It's not a linear story. And this is a wonderful quote. It's like a series of pictures, but it's not a series. It's a collection of pictures. It's disconnected and it's all over the place. And often the person is not going to be capable of reorganizing that into a linear story. So when you see a person on the stand and they're being challenged by the cross-examiner, you got to understand that they are not seeing their experience in a way written like a novel. Next slide, please. Expect progressive disclosure. Here's the case that Michelle was speaking about earlier, the dueling case that most of us are probably familiar with. That was not a trauma-informed process. There might have been trauma-informed people. Maybe everybody was trauma-informed in the case, but in the courtroom, that process in the courtroom was not trauma-informed. And the judge commented about material inconsistencies between their description of the assaults and the statement given to police. Of course, that's what needed to be in that case. There needed to be someone explaining to a judge how the traumatized mind works. The Law Society of Alberta went after Mr. Blott. Was a Law Society disciplinary matter. They understood it's more of an inquisitorial process in the independent assessment process under the residential school settlement agreement. In that approach, there was an explicit recognition of progressive disclosure. It takes time. Next slide. Support for your client. You need to work with the appropriate supports during interviews so that they stay grounded. We probably have all had experiences of clients dissociating actively in a meeting, and you've got to know how to bring them back. Lawyers aren't trained to do that. You may need to have somebody there to do that. Afterwards, the last thing you want is your client heading home to Dawson or heading home to Ross River in their car and driving away with their mind whirling around. That's not safe. Throughout the case, just making sure your client feels involved and understanding the difference between passive support and therapy. Passive support makes a person feel good. Therapy helps them challenge and look for new coping strategies. I suspect I'm out of time. What have we got left here? What's our next slide? Okay. I'm not going to read the Bradshaw and Stenner test. Everybody's familiar with it. But in the context of what you've learned today, consider whether or not it applies to assessing the credibility of a traumatized person. Their ability and opportunity to observe events. We've just heard it doesn't work that way. A person may be actively dissociating during the event. They're not going to be able to observe what's happening. The firmness of their memory. Their memory is not static. It is evolving and it's based on those snapshots. And then there's these very subjective elements about what the judge is perceiving. I mean, the judge brings their lens to what they expect. Is it unreasonable, impossible, or unlikely? That's a very subjective approach to things. And I know that the fundamental of all this is based on the judges always go back to, did the evidence harmonize with independent evidence that was accepted? But we have to be careful of confirmation bias. We accept the evidence that fits with our view of the world. And I think it's time, especially in trauma cases, to reassess whether or not Bradshaw and Stenner should be applied. I think I've probably run out of time.
Thank you very much, Dan, for your reflections there based on like our other presenters, a lot of experience over many years. So I think we have time for one question. I'm just checking the chat room. And I'm going to read the question. It's from Darcy Tachuk. He said the question is addressed to all three panelists. So I'll ask one of you to work out between yourselves which of you would like to take the question. Here it is. As counsel, we have a professional obligation to our clients to test and challenge the evidence against our clients, often through vigorous cross-examination that may involve impugning credibility. How do we best maintain this professional obligation to best serve our client while respecting and understanding witnesses and victims who have suffered trauma or violence? That seems to me that's either a Dan or a Dr. Gale question.
Reagan, I can have a stab at that. That almost identical question came up in a talk put on by, I think, the Law Society of BC last week. And I think it's time to re-examine the tools that we have and how we use those tools, because they don't always work in a trauma situation.
Thank you, Dan, for that answer. It is approximately 1:29 minutes after the hour, which means we are now into our wrap-up phase. I'd like to thank each of our presenters today, Dr. Gale, Michelle, and Dan. I'd like to thank all of the participants. We've had close to 100 people register for this event. I'd also like to thank the Law Society's Professional Development Committee for this particular presentation, but also for all the other ones that they do during the course of the year. And don't forget, just before we leave, don't forget that this presentation today is provides 1.5 PD hours for both the BC and Yukon Law Society. And the next offering from the PD committee, just to change up the pace a bit, is construction law, May 24th. It's on the website. Check it out. Thank you very much to everyone. And this is the end of today's presentation. I hope the rest of your day is as spectacular as it is in Whitehorse right now.
Thank you very much, Tom.
Thanks, team.